Section 6.1 Flips and 90-day rule for financing property. Flipping. Property flipping is the practice of buying a real estate property, typically at a lower price, and then quickly reselling it at a higher price to make a profit. This often involves making improvements, renovations, or cosmetic upgrades to increase the property's value before selling. In some cases, flipping can also refer to buying undervalued properties and reselling them without major repairs, depending on market conditions. When purchasing a flipped property using FHA or VA loans, specific guidelines and restrictions apply to ensure fair practices and protect buyers. FHA loan restrictions on flipped properties. The Federal Housing Administration, FHA, enforces the 90-day flip rule, which stipulates ownership duration. Sellers must have owned the property for more than 90 days before it can be sold to an FHA buyer. If the property was acquired less than 90 days prior, FHA financing is not permitted. This means that the buyer cannot even sign an offer to purchase until the 91st day. Make sure that the owners, flippers, have recorded their purchase. The time clock starts the day the flippers recorded their purchase. They could own it for 6 months and then record their purchase. The 90-day rule would start the day they record the purchase of the property when the flipper bought it. 91 180-day resale. If the property is sold between 91 and 180 days after acquisition, and the resale price is 100% or more above the original purchase price, the following are required: a second appraisal at the lender's expense, documentation justifying the increased value, such as records of substantial renovations. Exceptions. Certain transactions are exempt from the 90-day rule, including sales by HUD, other government agencies, or nonprofits, properties in presidentially declared major disaster areas, inherited properties, VA loan considerations for flipped properties. The Department of Veterans Affairs, VA, does not have a formal flipping rule akin to the FHA's. However, certain conditions apply. Occupancy requirement. VA loans are intended for primary residences. Buyers must intend to occupy the property within 60 days of closing. This means that using a VA loan for flipping is permissible if the buyer lives in the property during the renovation, a practice known as a live-in flip. Lender discretion. While the VA doesn't impose flipping restrictions, individual lenders may have their own guidelines. For instance, if a property's resale price significantly exceeds its previous purchase price, e.g., by more than 20%, a lender might require a second appraisal to validate the value increase. Key takeaways. FHA loans, subject to strict flipping rules, including a mandatory 90-day ownership period and potential additional requirements for properties resold within 91 to 180 days. VA loans, more flexible regarding flipped properties, provided the buyer meets occupancy requirements. However, lender-specific guidelines may impose additional conditions. If you're considering purchasing a flipped property with FHA or VA financing, it's crucial to consult with your lender to understand any specific requirements or restrictions that may apply to your situation. And make sure the property was recorded by the flippers. When flipping a property, disclosures about ownership history are very important, both on the MLS and in the seller's property disclosure statement, SPDS. Here's a clear breakdown. MLS disclosures. Ownership status. On the MLS, the listing agent must accurately disclose who the seller is. For example, an individual, an entity, like an LLC, or a bank, if it's a foreclosure resale. A real person needs to sign as manager or trustee for the trust or LLC. Short-term ownership. If the property was purchased recently, such as within the last 90-180 days, the listing usually must note that it's a recent resale or flip. The listing agent may not put FHA as an accepted new financing possibility due to the 90-day rule. This helps agents and buyers understand that there may have been renovations or changes that should be carefully reviewed. Disclosure of material changes. If the property underwent major repairs, remodeling, or improvements, many MLS systems, like RMLS in Arizona, require agents to disclose that significant changes have occurred since the last sale. This would be put on the SPDS. Remember that the owner may say they never lived there. They should still have some, even if it is limited information on the property. Utilities, repairs were done, and defects were found that were taken care of during their flipping time. SPDS, Seller's Property Disclosure Statement. Disclosures. Length of ownership. The seller must disclose how long they have owned the property. There's a specific question in the SPDS asking this directly. Line 4 of the SPDS asked what date the owner acquired the property. Knowledge of condition. Even if the seller, flipper, has only owned the property a short time, they are still required to disclose any material facts they know about, any repairs, remodeling, or upgrades performed, whether they did them personally or hired contractors, whether permits were pulled for major work, utility info and mailbox location, as is, sales. Even if the property is being sold as is, disclosure obligations do not go away. If the flipper knows of prior damage, repairs, or defects, even if repaired, they must disclose that information. The residential purchase contract is an as-is contract. The buyer is to understand that the property should be in the same condition at close with agreed-upon repairs as it was upon acceptance. Special attention to water, mold, and structural issues. Because flipping often involves fixing distressed properties, sellers must be careful to disclose anything relating to prior water damage, roof issues, foundation cracks, mold, etc., even if they believe the problems were fully corrected. They would just have to put that in the SPDS as bathroom faucet leaked, mold and damage were remediated, and no further issues have been noticed. Bottom line, on the MLS, the recent ownership and major repairs must be truthfully disclosed. It may not be correct in the monsoon or even the county tax records. In the SPDS, the seller must disclose how long they own the home, any known repairs or defects, and any material facts, even if the seller was not the original owner when the issues first arose. An agent's due diligence. When a seller refuses to provide an SPDS, explain the importance of disclosure. The agent must educate the seller that providing the SPDS is in their best interest. It's designed to protect the seller by showing they disclosed known facts, reducing liability for non-disclosure claims later. Document the refusal. If the seller still refuses, the agent should get that refusal in writing, e.g., a signed statement or an email, confirming that the seller declined to complete the SPDS despite being advised to do so. Warn about legal risk. The agent should advise the seller in writing that refusing to disclose known material facts could expose the seller to legal claims for fraud, misrepresentation, or breach of contract, and that Arizona law, and many states' laws, requires disclosure even without an SPDS form. Disclose what is known. Even if the seller won't provide an SPDS, the agent still has a duty to disclose any material facts they know or should reasonably know about the property. AAC R428-1101. Example: if the agent sees signs of a roof leak, termite damage, or a flipped property that had major repairs, they must disclose that to buyers, even if the seller won't. Recommend independent inspections. Because there's less information from the seller, the agent should strongly recommend that buyers conduct thorough inspections to protect themselves. Quick summary. An agent's duty to disclose material facts doesn't go away if the seller refuses to complete an SPDS. The agent must still act honestly, advise the seller appropriately, and disclose anything they know that could affect the property's value or desirability. Every buyer is entitled to a SPDS. Every buyer should receive a seller's property disclosure statement, SPDS. The revised AAR Residential Resale Real Estate Purchase Contract Form, the contract, recognizes the importance of the SPDS and provides Seller Property Disclosure Statement, SPDS. Seller shall deliver the SPDS to the buyer within five days after acceptance of the contract. Thus, pursuant to the contract, the seller is required to provide a SPDS in every transaction. Some sellers are reluctant to provide a SPDS. However, where a seller of real property knows of facts materially affecting the value of the property that are not readily observable and are not known to the buyer, the seller is under a duty to disclose those facts to the buyer. Hilva Jones, 151, Arizona 81, 725 P. Tude, 1115, App here, 1986. Additionally, pursuant to the contract, the seller is obligated to disclose all known material latent defects that materially and adversely affect the consideration to be paid by the buyer. The SPDS will evidence the fact that the seller has made these required disclosures. Sometimes, a seller will initially refuse to complete a SPDS on the basis that the seller has never occupied the property or perhaps has never even seen the property. However, if the seller owns the property, the seller should be able to answer most of the questions in the Ownership and Property section of the SPDS. For example, even an institutional seller who has never seen the property can disclose the address of the property date acquired, disclose whether the property is located in an unincorporated area, identify the legal owner of the property, disclose whether the legal owner is a foreign person or a non-resident alien, pursuant to the Foreign Investment in Real Property Tax Act. Indicate whether the property is in a community providing housing for older persons, pursuant to the Fair Housing Laws. Indicate whether the property is owner-occupied, leased, estate foreclosure, or vacant. Indicate if the property is vacant, and for how long. Indicate if the property is rented and the expiration of the rental agreement, and disclose whether refundable deposits or prepaid rents are being held. Disclose whether the owner has entered into any agreement to transfer an interest in the property in any way. Utilities. Additionally, most sellers know whether the property is in a homeowners association, HOA, and whether there are HOA fees. Arizona law mandates seller disclosure of these and other HOA issues in HOAs with fewer than 50 units. The seller may also be aware of assessments, litigation, or liens affecting the property. Most of the questions on the SPDS ask only for information of which the seller is aware. However, if there are questions on the SPDS for which the seller does not know the answers, the seller can simply use the explanation lines to explain. The fact that certain information is unknown to the seller and why it can be important to the buyer. Despite the foregoing, some sellers still refuse to provide a SPDS. If a listing states that a SPDS is not available or will not be provided, a buyer's broker should nonetheless advise the buyer to request the SPDS in the offer. The seller can respond to the offer requesting a SPDS with a counteroffer that a SPDS will not be provided. However, before the buyer accepts the counteroffer indicating that a SPDS will not be provided, the buyer's broker should provide the buyer with a blank copy of the SPDS form, which will enable the buyer to make an informed decision regarding whether to waive the SPDS. In these circumstances, a buyer's broker would be wise to obtain the buyer's written acknowledgement of receipt of the blank form. A buyer should never waive a SPDS without seeing the SPDS form. Even a blank SPDS is valuable to the buyer. The buyer can and should utilize a blank SPDS as a checklist in conducting the desired inspections and investigations. The SPDS can prompt questions that will assist the buyer in evaluating the property. Clearly, the SPDS is a valuable tool for both buyers and sellers in a real property transaction. Therefore, every buyer should receive a SPDS. The SPDS, Seller's Property Disclosure Statement, itself is not required by law in Arizona. But disclosure of material facts is required by law. Here's the breakdown. Arizona law, ARS, PR 32-2156, and case law requires sellers to disclose all known material facts about a property that could affect its value, condition, or desirability. The SPDS form is simply a standardized tool created by the Arizona Association of Realtors, for example, to help sellers meet their legal obligation. Sellers aren't legally forced to fill out the SPDS form, but if they choose not to, they still must disclose any known material problems another way, written or verbal, though written is best to protect everyone. Agents must recommend and encourage sellers to complete the SPDS because it documents disclosure and can protect the seller and agent from claims later. Bottom line, SPDS, helpful tool, not legally required. Disclosure of material facts, absolutely required by law. Note: on the cover page of the SPDS it says, if you are using the Arizona Association of Realtors, STOPS, AAR, Residential Resale Real Estate Purchase Contract, the seller is required to deliver a completed AAR residential SPDS form to the buyer within 3 days after contract acceptance. If the seller does not provide the SPDS as the contract requires, the seller is potentially in breach of the contract, thereby enabling the buyer to cancel the transaction and receive the earnest money deposit.